All right, welcome back. We are going to continue with our contempt webinar brought to you by O'Neill Wasaki Family Lawyers. And this session is about contempt enforcement pleadings, both affirmative pleadings and defensive pleadings. So we're still joined by Jerry Height and Carrie Bertrand with my law firm. And we're joined by retired Judge Bill Harris out of the 233rd in Tarrant County. So kicking off pleadings. Pleadings are important in contempt litigation, aren't they?
They are. They're very important. It's where a lot of people mess up.
Yeah. So obviously we have the Texas Family Law Practice Manual, which is a start.
It is.
It's a start. What is important to be pled in a motion or a petition for contempt?
You want me to take
Yeah,
it?
you take
well,
that.
You have to reference and attach the underlying order that you're trying to, for the basis of contempt. You have to list individually each specific act of contempt, and sometimes people will mess that up. You have to identify the time, place, exactly what happened for each one. And then you have to, that's where the main area where people get messed up.
Right.
I've always said that when I look at a contempt pleading, I look at it the same way as if I was trying a criminal case. I would look at the information or the indictment. It has to be
Right.
clear that to where the indictment wouldn't be subject to quash or something like that.
Right. I think there was a McNamee case on that, 605 Southwest 2nd, 353. We'll post that in the comments. That said that basically you plead each count separately like a misdemeanor complaint.
Yes.
Right.
And I think that for family lawyers, most of them haven't done criminal law. So I see this as a place where so many people, especially when I'm defending a contempt case, that this is a place that people kind of tend to mess this up. This is a place where you can kind of trip up a party who's prosecuting a contempt.
I've seen a lot of contempt complaints, petitions where they say that that John Doe was ordered to pay child support on the first of each month, beginning so and so, the first of each month thereafter, and he failed to do so. Well, he's a bad guy, but you can't hold him in contempt over that because it's just not. It has to say he failed to pay that child support on this date, this date, this date. She failed to allow the visitation or possession and access, surrender the children this date, this date, this date.
Yeah.
And it's just,
Yeah. So how does a family lawyer approach pleading a contempt pleading like this if they've never done criminal law?
Well, in my opinion, there's some things I've always told people to look at in orders and look at in the pleadings. And you want to know that the order is valid. And there are several things on family law orders that a lot of people mess up on, and it is amazing to me how many times these things happen.
So give me an example.
Motion for new trial.
Okay.
Filed and granted. Granted on one day, and then signed the order granting the new trial. Docket entries made on one day. 31 days later, the order's signed. The contempt based on that judgment's void, because that judgment's void.
Right.
I see a lot of these we have had a couple of judges in Tarrant County that believed that they could reinstate dismissed cases that were dismissed for want of prosecution, and they believed that they could reinstate them with a docket entry. And there was never a signed order reinstating the case. Well, the ensuing judgment is void.
Yeah. Yeah.
And the biggest culprit that I've seen is it's a terrible tool is a nunc pro tunc judgment, because people use nunc pro tunc judgments to fix screw ups. They want to call it, they say, oh, this corrects clerical error. It doesn't. It corrects judicial error, because clerical error is the error that occurs from the time I render to the time it's signed. If it's not, and in most of our divorce custody cases, the rendition and judgment are simultaneous.
Mm-hmm.
So you cannot have, by definition, you can't have clerical error. If there's a misspelled name, a misspelled date, that's judicial error.
Yeah.
You got to correct that with a motion for new trial. You can't correct it later with an nunc pro tunc. And if you try, the order's void. And I didn't realize this till I got to doing some research on it. It's not voidable; it's void. So.
And a void order is not contemptible.
Not contemptible.
Yeah. So, so Carrie, you spent many years before you went to law school as a paralegal, expert drafting, and then you've gone to law school and now you're a practicing attorney. So drawing on both of those experiences, like how do you approach drafting a petition for contempt to make sure that it's specific enough to seek the relief that you want to get?
Well, and I was Jerry Hyde's paralegal, so I was taught well, and everything has to be just so. And I think the first problem I would notice in other people's pleadings is they actually didn't even copy the order language into their pleading correctly, which is just, yeah, I know.
I've seen that many
So,
times.
okay, so let's pose this question.
Well, that order didn't work, so you just change it a little bit so it does, is what they do.
Yeah.
I'll say what I want it to say.
Right.
So, okay, so is it sufficient to incorporate the whole order by reference versus quoting the order in the petition?
I think it's sufficient.
Okay.
I don't particularly like that because I don't like the whole order being attached.
Right.
But I do believe that it satisfies if it's incorporated, attached as an exhibit, like Jerry was talking about earlier. If it's just incorporates it but doesn't attach it as an exhibit, I don't think so.
Yeah.
So.
Okay. So if it references the order, doesn't attach it as an exhibit, and says it's on file with the court, sufficient or not sufficient?
I don't think so.
So if it quotes the portion of the order verbatim, but doesn't attach the order, sufficient or sufficient?
Yes, sufficient.
See, I think I disagree with that, because I think the code actually requires the order to be attached.
Jerry and I always do both.
Yeah, I always do both. I mean, I always
Better safe than sorry.
err on the side of caution.
I think that's a very good idea. But I believe that if it alleges it, that I think you're good enough.
And that's why I love having these webinars like this with the discussion, because you can have an opinion and we can talk it through, and everybody benefits from both of our opinions. So, okay, so then what Carrie was saying is quotes the order but makes a mistake in quoting the order. So sufficient or insufficient?
If it's not attached, I would say insufficient.
If it is attached.
Insufficient. If you misquote the order, then you're not getting anywhere.
We call that a fatal variance.
A fatal variance. All right. So then do you have to allege specifically that the respondent knew the terms of the order?
It's not implied in the order language?
That's my question.
I don't think so.
I don't think you do.
Because, your culpable mental state on that is not, there's no, contempt doesn't have a culpable mental state. It's just, did you violate it?
Right. But you had to know about the order.
Knowing, yeah.
Like, for example, if it was a default order. Mm-hmm. I mean, do you have to prove that he got a copy of the order? Do you have to prove that he knew about the order? I mean, or can you just contempt somebody for violating an order that they were defaulted in and never knew about?
Nope.
I believe
Not on default.
Cherry, correct me if I'm wrong.
If they're there I'm sorry, go ahead.
On a default order, doesn't the law presume that the clerk mailing the order, there's a presumption of delivery, and therefore
I believe, yes, you can get contempt on a default order. Now, what
Yeah.
you're saying is that you can if the person's not in the courtroom for the contempt hearing,
Right.
which I agree with.
Oh, yeah.
You-
Right.
you know, that's a different issue.
Yeah, sorry, I was unclear in my
Now,
scenario.
there is a time where you have to prove knowledge of the order for contempt, and that's when you're trying to get a third party held in contempt. You're trying to get grandma for keeping the kids away from the rightful, dad or
Right,
mom.
right.
There, you have to show that she actually had knowledge of the order to get contempt against her. But I don't think a party. I think a party, it's attributed to that they have knowledge of the order.
Okay. All right. So, what about? So we talked about describing each act. So you have to have a separate violation paragraph for each specific little violation of the order, right? Which can turn in how many do you remember, Judge? How many is the most number of violations you've seen pled in one petition?
I've seen a couple of contempt petitions where there were over 150 violations.
I think
pled.
that's the most I've seen. I saw one with over, I think it was 197.
I think you're right.
May have been the same case.
I've always told lawyers that if you're going to plead contempt, criminal contempt particularly on a child support case, pick your best 3 or 4. I mean, the ones where they're just
No
dead
question.
to rights, no question, and prove those up. Then shut up, because.
I think from a strategy perspective, I agree with you. I don't really recommend pleading a petition for contempt that pleads 197 violations because there's one of a couple of problems with that. One problem is that you probably can't really prove up all 197 of them. Another problem is that a judge isn't going to give you a trial long enough for you to prove up all 197 of them with time limits. And the other problem is that you kind of work yourself into a corner when you do that for a couple of reasons. One is that what if one of those violations isn't contemptible and you've got only one punishment? Then you've got a void order and you're going to have the guy walk without sticking the punishment on the ones that are punishable. And then I think the other problem is, or the other strategic issue is, that you could plead 3 or 4 violations, have a trial on those because those are then subject to double jeopardy because we're in criminal land here, and then come back, regroup, and 6 months later when they get out of jail on those 3 or 4, then come back and file 3 or 4 more.
Well, I think that the former jeopardy bar is a real valid concern. Because there's a variation on that where you say these contempts that say, and it's in the family law practice manual, based on his conduct, the petitioner believes that he will violate the orders on this day, this day, this day. Well, I've never found anybody guilty on it. Even when they did, in fact, violate the order, you can't find them guilty on that. Right. And I'm not so certain that when you allege future violations, you're creating a former jeopardy bar if they do violate those
on those
provisions
violations.
in the future.
Yeah.
That's a very good point.
Yeah. So, and so then requesting the contempt remedies. Obviously, your contempt petition has to specifically set out your remedies that you want, your enforcement remedies, your contempt remedies. So contempt remedy would be your civil or criminal contempt punishment. So what does that look like in a request in a petition, Carrie?
You're going to have to state if you want jail and fines and how you want the jail time served.
Okay. So on a criminal contempt, it would be up to 180 days in jail. On a civil contempt, it would be, I guess, up to 18 months in jail or until they comply.
Yeah, it's indefinite until they complete the action you're asking them to complete.
So, so what if you have a contempt petition that asks for 5 years criminal contempt?
Well, you can do that. You can plead for consecutive sentencing. There's 2 bad things about that. First is, it's going to have to be so horrible a contempt scenario. it's almost unimaginable that a judge is going to sentence somebody to more than 180 days in jail. You can do it. You can ask for consecutive sentencing, and that's available. The other thing that does is the request for consecutive sentencing triggers the right to a jury trial on the contempt.
And then you've just bought yourself a mess.
You've got
An
lot
expensive mess.
Exactly. So you're really kind of looking for trouble when you do that. I've actually sentenced people consecutively for like 2 times, but it's just on the most aggravated circumstances.
Yeah. So then you also can request your non-contempt remedies. So those would include clarification, judgment, granting a judgment, specific performance, whatever of those non-contempt enforcement remedies that you also want. And then you can plead for attorney's fees in your contempt motion. And then you also have to have your prayer, obviously. I think sometimes we get so reliant on the form book that we forget that in technical rules of pleading, you have to have a prayer that sets out the exact relief you're requesting, not just everything I've already said kind of prayer. So anything else on the petition itself, on the affirmative request for contempt petition? What about concurrent and consecutive? I think this is a place where doesn't the family law practice manual, it's not super clear on this concurrent versus consecutive question.
Well, I always ask for concurrent, especially if I have a lot of violations.
Why is that, Mr. Height?
Well, because, as the judge just stated, the odds of getting consecutive
It's a mess.
sentencing is nuts, and you're opening up a lot of doors that you don't want to go through if you're asking a bunch of consecutive 180-day.
Yeah. Because if you ask for consecutive sentences and it aggregates to more than 180 days, you're entitled to a jury trial. Or the defendant, the respondent's entitled to a jury trial. And then you've got a problem.
I had a case right after I went on the bench. I had a client who was not always good about paying his child support, and he'd been filed over contempt by the Tarrant County Domestic Relations Office twice. And I had gone down there and worked something out for him, and he thought that he was just, I was just the champ on this, and nothing to it. I just worked something reasonable out. Well, he got a contempt filed on him right after I went on the bench. He decided that he had been down there often enough where he knew that law. And he demanded a jury trial. And it was in front of a visiting judge, and the visiting judge granted it. And this visiting judge was not aware of the fact that the court has to set punishment on contempt. And she charged the jury on 7 counts of contempt. And they sentenced him to 180 days in the Tarrant County Jail on each count.
Oh, gosh.
Wow. That's crazy.
He got a lot of time in jail.
So what about where, let's say the petition seeks consecutive punishment and aggregates to more than 6 months, but in the hearing, the lawyer for petitioner stands up and says, "Oh, I didn't really mean that." Jury trial or no jury trial?
Jury trial.
What if the judge says no jury trial, but then ends up sentencing them actually to more than 180 days in jail?
Void order.
Yeah. So I had that happen in a case. We'll post it in the comments in Ray McRae, where the lawyer for the petitioner pled the consecutive, but then said in court affirmatively she didn't really mean it. She just meant to cap it at 180 days, but then the judge actually sentenced and left in the order. They did this fill in the blank order and left the word consecutive in the order, and the judge signed it with consecutive in the order. And writ granted, void contempt, and get out of jail free card. And the most important part is, and double jeopardy attached, so you can't go back and retry. You know, you can't. It's not like civil world where you get a new trial and you can go back and start over. Like, you're done. All those counts, again, if you pled all 197 of them, all those counts are done. So you're finished,
Jeopardy
and you
bar.
got to wait for them to violate some more. So another reason not to plead everything you got in the one petition.
And this may be, you may be planning on covering this later, but a lot of times there'll be a defect in the pleading, or there'll be a defect, something like Carrie was pointing out. It doesn't, recite the correct, order. Don't say anything if you're defending it. Don't say anything until the first witness gets on the stand and states their name, and then move for judgment, because
Right.
you're done, and you've got a former Jeopardy bar on all those contempt counts.
Well, and that is an important point you're actually hitting me a softball, so we can move to defensive pleadings. So with defensive pleadings, in normal civil world, you have to file, a pleading at least 3 days in advance of a hearing if you're seeking affirmative relief or whatever, and give fair notice to the petitioner that you're maybe seeking special exceptions or something. But in a contempt case, you don't have those rules, right? I mean, you can file your answer the morning of.
Yep.
You could bench file your answer once you're in the courtroom, right?
Yeah.
And what you're saying is that that's probably the preferred method.
If you can see a defect, I think it is the preferred method, because you get
Double jeopardy.
you get that Jeopardy bar.
Yeah.
And the law on criminal procedure is that jeopardy attaches when the first witness says their name.
Yeah.
So
Yeah. So what about, in answering a contempt petition, a normal general denial answer is not required. But what about pleading affirmative defenses? I still think you have to affirmatively plead your
If you've got them, you have to. Yes.
I believe that's correct.
So do you think, what's the timing of filing your answer with your affirmative defenses?
I don't know if you have to give much notice,
Right.
any notice to the petitioner as to your affirmative defenses. It's not like a civil suit.
Right.
So I think you can still file your answer the day of trial
The morning of?
and
Yeah.
assert affirmative defenses.
I think I agree with that, because you're talking about a criminal case here,
Right.
and there's constitutional implications on all this.
So what types of affirmative defenses get pled in a contempt case? Probably depends on the type of contempt, but let's start with child support contempt. So what are some affirmative defenses that somebody might plead in a child support contempt case?
Let's say the primary conservator voluntarily relinquished the child to me, and I've been supporting this child during this time, so I shouldn't have to pay child support. That's
Yep.
the main one I can think of.
Okay.
Inability to pay.
Yep. So an inability to pay, there's a difference between civil contempt and criminal contempt. So with civil contempt, the inability to pay is not only at the time it was due, but also at the time of the hearing. In criminal contempt, it's at the time it was due. Although I think there's some case law that has made a little bit more confusion out of that, as from our splitting hairs of it. But that's my understanding of the distinction of inability to pay. Although if I'm going to present an inability to pay defense, I'm going to prove up that they're just broke
Right.
all the way around. Because the code requires that with an inability to pay, that you have to show that it's not just that I didn't have the ability to pay on this date. Like, you've got to say, and I couldn't go borrow the money,
Right.
and even my mama wouldn't give me any money, and I don't have a house, and I couldn't
No
go get a
property.
second mortgage, and I don't have a HELOC to get a line of credit against my mortgage, and I don't have any credit cards to use to pay it, and I couldn't have gone and hawked my watch, and I had nothing of value that I could have taken to the pawn shop, right? I mean, it's not just like my pockets are bare. I mean, it goes a little farther than that, right? What about with, say, a possession contempt? What are some affirmative defenses that could be pled in a possession contempt? To me, the most obvious one is the failure of a condition precedent.
Yeah.
That I've seen impossibility.
The child
raised.
is too old. Yeah.
And the child refuses to go.
That-
Right.
I tried to get the child to
Right.
go. I told the child to go, and the child would not go.
I tried a case where they had alleged visitation violation, and the mother had a driveway camera pointing down the driveway, and she, the video that we played, and this was connected with a custody trial, played to the jury. They walk down the driveway. She walks down the driveway with the children. She kisses 3 of them, says bye, and she walks back, leaving them at the van with their father. And they just would not get in there. So, my thought was she complied with the possession order. She relinquished possession.
This happens a lot with teenager possession orders.
Yeah.
So when you were on the bench, Judge, kind of what was your opinion of teenagers being teenagers and possession orders?
There's a case out of Houston, I think, that said that you have to use everything short of physical violence. I never followed that line of reasoning. I think you have to make a reasonable effort. That's one of the reasons that possession cases are really sort of unfair, because possession cases, and I'm being gender-wise, it's getting where it's not quite so clear, but typically support cases, it's the female receiving the support. Possession cases, it's the male not getting visitation. And the support cases are so incredibly easy to prove. The possession cases really aren't, because you've got all these factors. The kid didn't want to go. The kid, wouldn't get in the car. Well, how hard did you try to get it? Well, how hard do I have to try? Do you want me to? You want me to beat him? I had a club with me, but
right, so, drag them by their hair.
Exactly, taser them. I don't know, but
and then whenever a teenager gets to be of driving age,
right, that's when they're voting with their feet.
Yeah, I think by that point, if you are having trouble getting them to come visit with you voluntarily, you kind of lost the war.
And it's really even worse than that is when they turn 17.
Yeah.
Because if the judge tells them to go visit and they tell the judge to jump in the lake, there's nothing the judge can do.
Right, because by then they're an adult under Texas law. So what about discovery? Is discovery available in a contempt case? I don't know that this is a question that's decided, so I don't think there's an answer. But.
I think that there's a Fifth Amendment problem if you're trying to discover from the contempt order.
What if the respondent wants to do discovery of the petitioner? Send to a RFD.
Yeah, I've never seen that before.
I tried it in a case.
Did you?
I think it makes more sense comparing it to a purely criminal system that would work, because the state has to show their cards.
Right.
Exactly.
I think if it's a civil contempt too, I think arguably discovery could be available.
Yeah.
I don't know
so.
of anything that says you can't.
Well, I mean, if it's a criminal contempt case, file a Brady versus Maryland motion. That's as simple as that.
Yeah.
See what
I
the
don't know.
judge said.
I've never seen that done, but I may do it next time.
I've never seen it either. But
Well, there you
I've
go.
never seen a Brady.
There you go, everybody. The price of admission.
Brady motion in a civil case.
So we've got about 2 minutes left. Let's talk real quick about the constitutional implications of notice and service of process. So, Carrie, you want to kick us off on that topic?
Sure. If you're going to try to restrict someone's personal liberty, you need to personally serve them. You need to personally serve them with a copy of your petition and with a copy of the notice of hearing. And they both need to be signed, or the notice of hearing needs to be signed by the judge.
So what happens when the hearing gets reset?
You need to appear at the original setting and be ordered to reappear at the reset date.
The respondent needs to be
Yes.
ordered to reappear. Or what's the alternative?
You could issue the notice again,
Right,
and
and
serve
have it
it.
personally served again. So there's been a whole lot of cases where it gets reset and the respondent doesn't get reserved. So what happens to your contempt remedies if the guy doesn't get reserved?
They're gone.
Yeah.
They're gone. You can't put them in jail. Writ granted.
You're just other enforcement issues. is
Writ
what you're doing.
granted. So, all right. Well, that brings us to our 30 minutes on this section. So we are finished with this one. We're going to take a little bit of a break. Stay tuned. Our next one is on proving and defending the contempt case in trial, the strategies for handling it in trial. So we will be right back. Keep in mind that this is a webinar that's aimed at attorneys. This is for continuing legal education. If you're out there watching this webinar and you're not an attorney, we welcome you to watch it. But remember that we are not giving you any specific legal advice. We cannot comment on any specific case or situation without knowing all the facts. So if you need legal advice, this webinar is not a substitute for legal advice. Please, please seek the advice of a lawyer as to your specific situation and get specific advice to that. Because if you rely on just what we're talking about here, we're being general, we're talking about general legal principles that may not actually apply to your situation. This is for continuing legal education only, and we cannot create an attorney-client relationship just through the video camera. Okay? Thanks.